ಹಲೋ. ಸರ್ ಇದು ಹೋಸ್ಟ್ ಇದು ಮಾಡಿದ್ರಾ? ಅದೇ ಕ್ಲಾಸ್ ಸ್ಟಾರ್ಟ್ ಮಾಡೋಕ್ಕೆ. ಹೌದಾ? ಓಕೆ. 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 ಒಂದು ನಿಮಿಷ ಮ್ಯೂಟ್ ಮಾಡ್ತೀನಿ. ಸ್ಕ್ರೀನ್ ಶೇರ್ ಆಗ್ತಿದೆಯಲ್ವಾ? ಹೌದಾ? ಓಕೆ. ಇವಾಗ ಆಗ್ತಿದೆ ಅನ್ಸುತ್ತಲ್ವಾ? ಓಕೆ ಸರ್, ಆಯ್ತು. Okay, so yesterday we have learned about you know contracts and agreements, and agreement enforceable by law is known as contract. And uh, I have also told the definition, and according to section 10, uh, agreement to be enforceable, it must be competent, parties must be competent to contract made by the consent of the parties, and it should be made for some consideration. Consideration must be lawful, and the agreement must not have been expressly declared to be void under the Contract Acts or any other uh, act. Okay, and so we have also discussed about classification of contracts, like based on enforceability, based on method of formation, based on extent of performance, and based on obligation. Okay, this we have discussed yesterday. And also proposal or offer and acceptance. What we call in India as proposal is also called as an offer in the English law. Okay, and classification of offers I have explained yesterday, that general offer, specific offer, cross offer, counter offer, standing open or continuing offers. I have explained about these things yesterday, whereas general offer can be made to general public and anybody can accept the offer, whereas in specific offer only it is directed towards one particular person or entity. Okay, and cross offers are where without the knowledge of other person, when two parties of make an offer, it will be called as cross offers. And counter offers is when one party make an offer and another party add some modifications or changes the original contract. In that case, it will, and he makes a counter offer. Okay, and standing open or continuing offer is there will be a certain period of time, like tenders and all those things, they are standing offer, and anybody can interested parties can take advantage of it. Okay, and essentials of a valid contract is that terms of the offer must be definite and unambiguous. Okay, the terms has to be clearly defined, and there should be no ambiguous ambiguous in there should not be any ambiguity in the contract. Okay, everything should be expressed and documented properly. It should not be unambiguous, and should be capable of being made certain. Okay, should not be loose, vague, or ambiguous. Okay, and offeree must have knowledge of the offer before he can accept it. So this is another essential element of the valid offer. Okay, where offeree must know, must have the proper knowledge of it for the acceptance. Okay, and an offer or uh, an offerer cannot say that if the offeree does not accept the offer within 2 days. Actually, an offerer cannot say that if within 2 days an offeree does not uh, accept the offer, it will be considered as offer accepted. So he cannot say that. Offerer cannot say that within 2 days if you don't accept the offer, it will be considered as offer. Without the communication from the offeree side. Okay, to whom it has been offered. So he has to be given certain time for him to make decision and agree to the offer. Okay, and settlement without any statement, without any intention of creating a binding obligation, only a mere declaration of intention to offer. Example, an auctioneer, where a mere declaration of intention to offer does not mean that it's an offer. Whereas, for example, an auctioneer, if he make a statement that there will be an auction on particular day or particular time, and another person travels 100 kilometers for this auction, and when he comes to know that the auctioneer has been cancelled the auction of a furniture, for example. uh, okay, if he has cancelled the offer, and the person who has traveled from 100 kilometers, he cannot claim that because of the cancellation of the auction. Okay, he cannot claim. He The offerer here, who has just made a mere declaration of intention to offer, does not he will not be liable to pay to the person who has traveled down the okay, for the auction. Okay, and offer must be made with a view to obtain acceptance and intention of creating legal relationship. Okay, it should be in the view of obtaining acceptance, and also it should create a legal relationship between the parties, and it must be communicated to the offeree before it can be accepted. Okay, this is the essential these are some of the essentials of a valid offer. Whereas, if no time is fixed by the offerer within which the offer is to be accepted, or there should be a reasonable time given for the offer. Okay, uh, sometimes the time will not be fixed for the offer. It doesn't mean that the offer will be remaining open forever. Okay, there will be some reasonable time until that it will be, even if the closing of the offer does the date or time will not be mentioned, still it doesn't mean that it will be there forever. Okay, within a particular time it will be, it depends on the circumstance of each case. Okay, and also must be distinguished. An offer must be distinguished from a mere invitation of offer. Okay, and next one is acceptance of an offer. Okay, it's as per the section 5.2b, acceptance is the act of giving consent to the proposal, where you'll be giving consent for the proposal. It's called acceptance. The accept Based on the section 5.2b. Okay, the acceptance of an offer may be expressed or implied, written or by words of mouth. Okay, where is expressed means, it's as I also previously told you in yesterday's class also, expressed in a sense, it can be in words or word of mouth, written. Okay, whereas implied means, it should be by performance of some required act of the offeree. Okay, it's called implied. And the essentials of a valid acceptance is that, um, okay, according to section 5.7, absolute and unqualified, and according to the exact terms of the offer. It should be according to the exact terms of the offer, and it must be communicated to the offerer. Okay, and also the valid acceptance must be given within the time specified. Okay, before the offer lapses, or in, just give me a minute. Okay, so before the offer lapses, it is terminated or revoked or withdrawn by the offerer. Okay, before that it should be accepted. Before the offer lapses or is terminated or revoked or withdrawn by the party. Okay, given by the person to whom the offer is made. However, in the case of a general offer, uh, the acceptance can be given by any member of the public. Okay, with regards to revocation of proposal and acceptance, a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterwards. An acceptance may be revoked at any time before the communication of the acceptance. See here, an offerer can revoke against the offerer if the communication has not been made of the acceptance, it can be revoked. Okay, in the same way, it can be against the acceptor also, and also proposer. Okay, a proposal is revoked by the communication of notice of revocation by the proposer to the other party. A proposal is revoked actually by the communication. How the proposals can be revoked in a sense, by the communication of notice of revocation by the proposer to the other party that he is terminating the contract. It can be revoked by the will and wish of the proposer. And if not, if no time is so prescribed, by the lapse of a reasonable time without communication of the acceptance. In a sense, I have also told you that there will be, even if the offer, if it is not accepted within the prescribed time, if the offer is lapsed, it will be considered as revoked, even without the communication of the acceptance. Okay, failure of the acceptor to fulfill a condition. Okay, in case if acceptor fail to fulfill the condition required, uh, again it can be revoked. Okay, proposal will be revoked. And also by the death or insanity comes to the knowledge of the acceptor before acceptance. I mean, if before acceptance, if they come to know that the other party has been has there has been passed away, or insanity comes to the knowledge of the acceptor before acceptance. Okay, it will be revoked. Okay, and next one is consideration. um, Actually, in a contract, the basic thing is that it's an agreement. It's an agreement enforceable by law, and as per that, there should be a consideration. Okay, consideration means something in return. Okay, it may be either some benefit con- conferred on one party, or some determined suffered by other. It may be an act, or assistance, or promise. Okay, here the promise, where they'll be making a promise, where in a sense, you can take an example of when you go to a restaurant or in any other places where they'll be or a cinema or something, they'll be providing services. Okay, services in return, their consideration will be the money what you will be paying them, and your consideration will be the services what you'll be getting. Okay, in a restaurant or in a cinema theater, where okay, so that's how the consideration parties, and it will be a promise made by the party to perform, or uh, discharge the duties or obligations. Okay, an agreement without consideration is not enforceable and therefore is void. Okay, if an agreement without consideration is not enforceable and therefore it is void. Essential requirement of consideration, or consideration must move at the desire of the promiser. Okay, it should be moved at the desire of the promiser. I mean, third party, even if the, I mean, based on the desire of the promiser, a third party can also provide the consideration in the in cases. Okay, consideration from promise or any other person. Okay, by desire of the promiser, as I told you that by desire of the promiser, someone else can also be, you know make the promise of the consideration. And past consideration, whereas the already some work has done or abstained from doing, as continued in section uh, as contained in section 2D. Past consideration, in a sense, for example, one person has you know provided some service or done some work, like for example, if a painter of a house who has painted, and the owner has told him to that he will pay him after a month. Okay, so where the painter has already performed the uh, work, and he can claim after a month, in case if the owner fails to discharge his duties. The painter can claim for the past consideration. Okay, and also next one is adequacy of consideration. Adequacy of consideration, in a sense, there should uh, there will not be any obligation that as per the law that equal consideration based on one party and the party who is also entering into contract. Both the parties don't have to be their value, their consideration value don't have to be equal. Okay, there can be variations. It doesn't have to, law doesn't say that the consideration should be equal to both the parties, where one party might get a little bit more than another party, so that will not be, that adequacy concern will not be there. Okay, and performance of what one is legally bound to perform. Next one is performance of what one is legally bound to perform. For example, government employees or government officials, for what they have what they are legally bound to perform, that they should perform, and another person, a third party, do not have to you know pay for that. For example, one person, a contractor who has been entrusted by the his superior to make some modifications or with the building with the building. Okay, in that case, uh, the person who is occupied in that building, if he unknowingly, if he says that he will pay after a month, I mean, if he say he'll also pay some money to the contractor, it doesn't mean that because he is legally bound to perform by his superior, it's his duty, whereas he don't have to take the remuneration from another person, from third party. Okay, whoever is the occupant in that building. Okay, and next one is capacity of the parties. Okay, anyone cannot enter into a contract. Okay, whereas he must be competent to contract according to the law, and every person is competent to contract if he is of a age of majority. If he is over 18 years old, if he has attained majority, then he can enter it into a contract. Okay, and he has to be sound minded. Okay, and he should not be disqualified from contracting by any law to which he is subject to, as per section 5.11. Okay, the flaws in capacity may be due to minority, lunacy, idiocy, or drunkenness, drug addiction, or status. These kind of things, I mean, hinders the capacity of the parties. Where the one party might be, if they enter into contract with these kind of parties, that the party who entered, another party will be suffering if they enter into contract with this type of parties. So because of this, it has been prohibited. Okay, and position of minor. Okay, whereas as per Section 3 of the Indian Majority Act of 1875, every person in India is a minor if he has not attained the age of 18 years. Okay, the position of minors agreement and the effect thereof is as under. Whereas an agreement with a minor is void ab initio. Okay, initially itself they cannot enter into contract. The law of estoppel does not apply against a minor. Okay, it means a minor can always plead his minority despite earlier misrepresentation to be a major. Okay, when entering into a contract, even if he has misrepresented himself as a major, uh, still, you know, he can plead not guilty. Okay, due to the minority. And doctrine of restitution does not apply against a minor, and minor cannot confirm an agreement made by him during minority or attaining majority. In case if they have entered into an agreement during minority, when they are minor, and they cannot claim it when they attain majority. Okay, a minor is entitled to enforce a contract which is of some benefit to him. Okay, whereas he can enter into a contract if there is some benefit into it him, and it's a personal privilege, and a minor can take advantage of it and bind other parties. But minor has the capacity to bind other parties, whereas he can also take advantage. and privilege of minority. And minor as an agent, he can also be appointed as an agent, uh, and but he will not be personally liable for his acts. Okay. And minor's liability for necessity, if someone has supplied a minor or his dependent with necessity, uh, it can be claimed, okay, against the minor, in case if the one party has provided the necessity. Okay. And other disqualified persons for the contract is that alien enemy. An agreement with an alien enemy is void, and it cannot be uh, for example, if two countries are in a war, or one country don't deal with another country, in case one person from this country try to contact or make some agreement with another party in the another country, the country which is like not tolerating or supported by the host country, will be will not be considered. Okay. It will be like alien enemy. Okay. And foreign sovereignty and ambassadors uh, they cannot enter into a contract. Even if they do enter, they have to enter through a agent. Okay. And convicts are like imprisoned, those who are in serving prison. Okay. So serving jail terms, those they cannot enter into contract. And insolvency means those who have already declared as insolvents. Okay. Those people cannot enter into a contract. And company or statutory bodies valid only to the extent within its memorandum of association. So this will be company or statutory body cannot be make liable. And there will be based on the extent to which its memorandum of association, what are the statements there, based on that only it can operate. Okay. And the next one is free consent. Okay. In free consent, there'll be coercion. Coercion, in a sense, committing or threatening to commit an act forbidden by the Indian Penal Code from 45 of 1860. Okay. So this will be forbidden by Indian Penal Code also. The coercion, in a sense, it's unlawful detaining or threatening to detain any property, okay, any property or prejudice of another person. It will be unlawful detaining, okay, or threatening is called coercion. And next one is undue influence, in a sense, whereas one party, like like religious gurus or some people who are in an influential position, use their influence to uh, influence the parties, influence the decision of the parties. That is called undue influence. Where is improper exercise of power over the mind of one of the contracting parties by the other is called undue influence. And it's not tolerated by the law. Okay. um, For example, I'll give you an example of undue influence, where if one person or a party is, going through suffering a disease, maybe because of the age, or is in a hospital, and another person who is attending that party, like medical attendee or someone, because of at the end he'll be taking care of the deceased party, aged party, and if he influences him to make decisions regarding his property, if he somehow influenced to get his property, or in that type of cases, it will be void. And it will be considered as undue influence, that the person has used, the medical attendant has used undue influence. Okay. And next one is fraud. Fraud, in a sense, fraud may be from the offerer or by his agent, with intent to deceive other party, where this is a willful deceiving of the another party, if they deceive willfully, without disclosing the by hiding the facts, it will be called as fraud. Okay, an active concealment of facts or promise made without any intention of performing it, or act fitted to deceive, or such act or omission as the law specifically declares to be fraudulent. Okay, if the law declares something as fraudulent, it will all be considered as fraudulent. Okay, and misrepresentation is whereas without the knowledge. Okay, sometimes simple actually misrepresentation is also known as simple misrepresentation, whereas fraud is known as fraudulent misrepresentation. Okay, in the simple misrepresentation, there will not be without knowing, a person may misrepresent. Okay, misrepresent the fact. Okay, incorrect or false statement, but the falsity or inaccuracy is not due to any desire to deceive or defraud the other party. Okay, without intention, if it has happened, that will be misrepresentation. Okay, and the next one is mistake. Okay, whereas mistakes are erroneous beliefs on the part of the parties to the contract. They believe that it is true or it is correct, but it will be a mistake. For example, A agrees to buy from B a certain house. Okay, in case A agrees to buy a certain house from B, and it turns out that the house has been destroyed by fire before the time of the bargaining. Though neither party was aware of the fact, the agreement is void. Okay, if the house has already been destroyed, and this party is one party is agreeing with another party, whereas they're unaware of the fact, it will be called as considered as mistakes. Okay, next one is legality of objects. Okay, next unit, in a sense, the object or consideration of an agreement must be lawful. Okay, legality of object is that what is an object? An object or consideration. A consideration is here uh, taken into as object. Okay, as an agreement, and it must be lawful. Okay, in order to make the agreement a valid contract, as per section 10 lays down that all agreements or contracts if made for lawful consideration and with a lawful object. Okay, the object of consideration uh, is what we uh, call, in a sense, the object of consideration will be like, as I told you earlier, one example I gave you for service providers. In case if you go to a theater or a hotel, the service what they provide, that will be object of consideration, and what money you will be pay, that will be object of consideration for one of the other parties. Okay, so section 23 declares what kind of consideration and objects are not lawful. Okay, illegal, and therefore void. The words object. Okay, the 23 section 23 declares what kind of consideration and objects are not lawful and illegal. Okay, if you go through the declarations of section 23, you'll come to know what are allowed under the law and what are not allowed, what are considered as void. Okay, the words object and consideration used in section 23 are not synonyms synonymous. Okay, they are not interchangeably used. They don't exactly they are not similar in a sense, they are saying. Okay, the word object here means purpose or design. Okay, what is the purpose or what is the design, what is the purpose for which the contract is made, and that is called as object. Thus, where a person while in insolvent circumstances, for example, an insolvent under insolvent circumstances, a person transfer his property to one of his creditors with the object of defrauding other creditors. In a sense, he sells his property, gives his property to only one creditor, whereas he has to pay to all the creditors. Okay, but he has done it in an object of defrauding other creditors. So it was held that the agreement was void and the transfer was inappropriate. He is not allowed to do that. Okay, that's unlawful consideration. A promise to obtain from B an employment in the public service, and B promise in return to pay rupees 10,000 to A. Agreement is void as the consideration thereof is unlawful. Like you cannot, it's like bribing to get uh, something in return. So that is unlawful. Okay, where A promises to obtain employment for 10,000 from B. So if he pays, it's called as unlawful consideration. Okay, and also there are things which are forbidden by law, and defeat of the provision of law, these are also considered as unlawful, whereas which is forbidden by the law, which is not allowed in the framework of the law, it's also considered as unlawful. Okay, and defeat of the provision of law, in case if some decision or some contract is uh, unlawful, if it is in contradictory to the law, that will be not be tolerated, and defeat of any rule of the time being in force in India. In a sense, that's what for the time being there will be certain rules and regulation. Okay, if in that case, uh, that cannot be defaulted, and fraudulents are also unlawful consideration. Okay, an agent for a zamindar agrees for money without the knowledge of his principal. Here the principal is zamindar. A is an agent of this zamindar who is a principal uh, to obtain for B a lease of land belonging to his principal, which this land is belonging to the zamindar, but his agent is leasing it to B without the knowledge of the zamindar principal. Okay, zamindar or principal, that person. Okay, the agreement between A and B is void as the consideration is fraudulent. Okay, okay, and another thing is this is a very important uh, aspect of legal business, where agreements opposed to public policy are void, and they are not tolerated in the court of law. For example, I told you earlier, trading with enemy. I mean, in case if there is war between two countries, okay, where if two countries are in war and one uh, person is trying to trade with another person in the another country, or who that time it will be a trading with enemy. It's not. It's against the public policy. Okay, and also stifling prosecution. An agreement of stifle prosecution tends to be a perversion or an abuse of justice. Okay, this is considered as a perversion or an abuse of justice, where one person is trying to tamper the prosecution process. Okay, that's not allowed. And champerty and maintenance. Maintenance is the promotion of litigation in which one had no interest, and champerty is being uh, bargain, whereby one party agrees to assist the other in recovering property with a view to sharing the property of litigation. In case if the person is helping the other person in because he wanted a share in the litigation profit. Okay, in that case it is against the public policy. Okay, and interference with the course of justice. And as I told you, the tampering or interference with the course of justice is also against the public policy. And marriage brokerage contract, and an agreement to negotiate marriage for reward, that is also considered as a against the public policy. Okay, and interest against obligation, an agreement by an agent to receive without his principal's consent compensation from another for the performance of his agency is invalid. Like if without the knowledge of his principal, if one agent is trying to make money, you know, from on behalf of the agency, it is not tolerated. And sale of public office, and as I told you that is not allowed, and agreement for the creation of monopoly. Okay, these are opposed, and they are against the public policy. Okay, next one is contingent contracts. Okay, actually, contracts are if there is no element of uncertainty. Okay, if there is no element of uncertainty, it is absolute contract. Okay, if there is any element of certainty, if it depends upon the happening or not happening of uncertain event, it is called as contingent contract. Okay, where a contingent contract is a contract to do or not to do something. If some event collateral to such contract does or does not happen. Okay, for example, a contractor A contracts to pay B rupees 10,000 if B's house is burnt. This is a contingent contract. You know, it's like for insurance companies and all. They and that's the type of dealing they do. Okay, so here the it can happen and it cannot happen. Okay, only in the case of happening of that event they will be liable to pay. Okay, only in the happening of uncertain event. Okay, in case of that uncertain event doesn't happen, it doesn't liable the party to pay. Okay, legally binding will not be there. Okay, in the same way, wagering contract. What is the wagering contract in a sense? A wagering agreement, says Sir William Manson has explained it as, is a promise. His definition is that is a promise to give money or money's worth upon the determination of an uncertain event. It is a promise. Wagering contract is a promise to give money or money's worth upon the determination of an uncertain event. You know, like win or lose or that type of thing. In case if it happens, they're liable to pay. That is a wagering contract. An agreement by way of wager is void. Okay, this is a void in the court of law. Okay, a future event which at the time of the contract is of an uncertain nature. That is to say, if the event turns out one way, A will lose, but it turns out the other way, A will win. In a sense, if the event happens, you know, like it's a betting wagering contracts, or most probably I think you may have known that cricket betting, or you know, like many other bettings what people do sometimes, you know, like they can win or they can lose, but it doesn't matter, but one person will be losing and one person will be winning. So this wager contracts or wager agreements are void as per the uh, law. Okay, and exceptions to the wagering contract is that transaction for the sale of purchase of stock. Okay, here the sale of purchase of stocks and shares, that will not be like betting. Okay, it will not be like betting, but it will be under the framework of the law. So these are there will be exceptions for these. Okay, these transactions like purchase of stocks and shares, and price competition, which are games of skill. um, Okay, example, picture puzzle, athlete competitions are not wagers. Okay, price competition. Okay, and also contracts of insurance are not wagering agreements. Uh, as I told you earlier about the insurance, where you know, in the future a certain event may or may not happen, but it will be insured by the. It will not be like wagering from the side of insurance company. Okay, but these are exceptions under the framework of law. Okay, and the next one is discharge of contracts. Discharge of contract. A contract may be discharged by uh, performance or mutual consent or subsequent impassivity or operation of law or breach. Okay, discharge of the obvious mode of discharge of a contract is by performance. Okay, that is where the parties have done whatever was contemplated under the contract, whatever was expected out of the under the contract. What they'll be performing it. The contract comes to an end. Okay, after that the contract will be uh, it comes to an end. Okay, so initially it will be about performance. Okay, and mutual consent in a sense where both the parties should be uh, mutually agreed upon. They should be agreed uh, on the transactions or whatever the rewards or the remuneration or the whatever they'll be getting in return, the consideration that should be both, that should be agreed by both the parties. Okay. And subsequent and also by operation of law. And there is also like a discharge of contract by uh, impossibility of performances. Sometimes the contracts cannot be performed due to its impossibility of performance. Okay, in that case it will not be used. And operation of law, it can be discharged. And there will be if the breach, I mean, in one party, if he fails to perform the duties, it will be called as breach of contract. Okay. Okay, remedies for breach of contract: when someone breaches a contract, the other party is no longer obligated to keep its end of the bargain from there. Okay, when someone breaches a contract, when one party breaches a contract, the other party is no longer obligated to keep its end of the bargaining from there. That party may proceed in several ways. Okay, the party may urge the breaching party to reconsider the breach. Okay, they can directly speak with the party who has breached the contract. And also, if it is a contract with a merchant, if the contract is with a merchant, if the contract is with the merchant, the other party may get help from consumer association, and the other party may bring the breaching party to an agency for alternative dispute resolution. Okay, they can bring to an agency for alternative dispute resolution, and the other party may sue for damages. They can sue for damages caused by the another party for breach of contract. And the other party may sue for other remedies also. Okay, for example, the damages according to section 75, another relief or remedy available to the promise in the event of a breach of promise by the promiser is to claim damages or losses. Okay, there's another party will be liable to claim for the losses. Next one is contract of indemnity and guarantee. The contract of indemnity and guarantee are the special types of contracts. They are species of general contract. Okay, accordingly, all the provisions of law of contract are equally applicable to them. Okay, they are species of general contract. Accordingly, all the provisions of law of contracts are equally applicable to them also. Okay, indemnity and guarantee. Indemnity means protection against loss. Okay, as I already telling you in the previous uh, slides also, that many means protection against law. Indemnity means protection against loss, especially in the form of a promise to pay or payment for loss of money, goods, etc. Money or goods, if they have lost, it will be like a promise to pay. Okay, it will be promise to pay to reduce the losses. Basically, it is a security against any default or compensation for loss. Okay, it's a basically security against any default. Okay, or compensation for loss. Okay, the special provision relating to contract of indemnity and guarantee are embodied in section 124 to 147 of the act. If you want in-depth knowledge of this, if you go through section 144, 124 to 147, you'll be coming across lot of related aspects of the provisions, in the law. Okay, a contract of guarantee. What is a contract of guarantee? A contract of guarantee is a contract to perform the promise or discharge the liability of the third person in case of his default. Okay, guarantee is kind of it's a promise to discharge the liability of a third person in case of his default. Like person who gives the guarantee is called the surety. The person is in respect to whom default the guarantee is given is called the principal. Okay, principal debtor. And the person to whom the guarantee is given is called the creditor. The person to whom the guarantee is given is called the creditor, and the person to whom the uh, for whose default the guarantee is given is called the principal debtor, and the person who is giving the guarantee is called the surety. Okay, rights of surety: surety against creditor, surety against uh, we can also check that surety. If you want to know the rights of surety, rights against creditor, surety against principal debtor, rights against uh, co-security, co-sureties. Okay, right of contribution. Okay, there will be like a third party can also be making the surety. Okay, in case there'll be special rights for them. Okay, and one more thing I want to tell you is that it's a very vast subject and there is a whole lot of things to cover, and we only provide you the basic idea so that you can all go through the study material, and also please go through the reference section in after each unit. There you'll be getting the details of the reference books where you can refer for a further clarification of all your uh, clarification and in-depth knowledge about the subject. Okay, and we provide, and I try to cover as much as possible with this short span of time. I try to cover and try to guide you and give you an entire idea of what exactly that legal aspects of businesses, and the things that it will be helpful for you. Okay, and don't just rely on this. You should also completely study the self-learning material what we have provided, so that will give you a complete idea. And also please read the reference books what we have provided in the detail in the end of each unit. Okay, that reference book will serve as uh, a guide. Okay, our study material will also serve as a proper guide for you about the subject. Okay, with this I want to thank you all for your patience listening. Okay, and thank you.